Well, quite recently, a federal high court sitting in Abuja issued a judgment restraining the Central Bank of Nigeria from disbursing funds or allocations to Rivers State government. Well, among other things, they cited misappropriation and not following due process in presenting the 2024 Rivers budget. Well, to make sense of all this new development is a political analyst by name Asim Adams. Good morning, Mr. Asim Adams. Can you hear us?
Yes, good morning to you. Good morning to you.
Good morning to you.
Yes.
So we would like to start off with this question. When the news of the judgment from the Federal High Court, when it broke, what were your thoughts exactly?
My immediate thoughts when this news broke was that for once, the judiciary, has, upheld the sacrosanctity of the 1999 Constitution. That is, that every form of impunity, be it by a Nigerian
All right, Mr.
citizen.
Adams, I'm sorry to
Yes.
interject. Could you sit up straight and properly so that the camera can capture your face?
Yes. Can you see me now?
Yeah, thank you very much. We can see you now.
Very good. So it was a very good news for me because the impunity, the ways the executive arm of government, have treated, dismembered the Nigerian Constitution has been very saddening. So when the court sat up and said, you cannot dismember the Nigerian Constitution and go scot-free. For every act of impunity, there must be consequences. So I was very, very elated with the judgment of Justice Joyce Malik. That is my first reaction.
All right, Mr. Adams, of course, a lot of people would have opinions and side talks. And in fact, I think on X, there was some kind of conversation coming up, people saying that this is as a result of the fraud happening between Wike and, Fubara. But what's your take on this? Do you really think that this is because of Wike, or do you think this is just a genuine reason?
It is just a genuine reason. Sentiments apart. You see, for those of us in Rivers State, we play politics of sentiments and emotions. Are you aware, that when the Supreme Court was to take decisions on the allocation of local governments, to them directly, people from Rivers State, especially those who support, one of the parties in this field, said that it was the Yeso Wike camp that is orchestrating, this particular, suit before the Supreme Court through Lateef Fagbemi. But I argued, I said, no, it is not true. Lateef Fagbemi went to Supreme Court against the 36 state governors in Nigeria, not just Rivers State, but those, political, Philistine carpetbaggers in Rivers State, who are supporting Sin, said it was orchestrated and choreographed by Yeso Wike, which is not true. Yes, it's not true.
All right, so you said that this is, let's remove sentiment, it is truly true. So yes, I want to ask now, can you explain the constitutional provisions violated by Governor Fubara's action?
Because of time, I will just encapsulate. I will not read copiously and studiously from the Constitution. But for those who are close to their Constitution, they should go to Section 90, Section 91, and Section 96. Now, I'm going to take these three sections combined, community reading, because of time. Now, Section 90 says there should be a House of Assembly of every state in Nigeria. Then you go to Section 99, it says that a House of Assembly of a state should not be less than 24 members. House of Assembly of a state should not be less than 24 members, and not more than 40 members. So which means each state or the federation, has the right, to apportion 24 members to the state, or 36 or 38, but no more than 40. In Rivers State, we have 32, and it is based on the representation in the House of Representatives. That is how the allocation came about, an allotment of seats in your House of Assembly. There are states that do have 24 as the minimum. There are states that have 26, depending on how many members they have in the House of Reps, times 3 or times 4. So now, if you go further in these areas I've said, the House of Assembly of a state, 3 members can sit. They can sit down and discuss and drink tea and eat jollof rice and, go back, to their various houses and resume tomorrow and eat jollof rice, drink tea, etc., as the case may be. But when it comes to a particular debate or area that 2/3 of majority of the House of Assembly, must, give their consent, they cannot sit down because they are not to 2/3. Now, when it comes to forming a quorum, what the Constitution say, and I challenge anybody listening to me, what the Constitution say is that 1/3 of members of the House of Assembly. That is what the Constitution says. And it goes further to explain, to say that wherever there's a sitting and a member finds out that members present for that day's session are not up to 1/3 of members in the House, what will happen is that the House will adjourn. They keep adjourning until they attain, 1/3 quorum. Because without a quorum 1/3, you cannot sit. The Legislative House cannot sit. That is why you find that even this particular present, Jumbo-led assembly, when the 27 members of the House of the PDP defected allegedly to APC in December of last year, the Jumbo-led or Ehie-led House of Assembly did not sit and deliberate on issues until January, February of the following year. They kept shifting and adjourning to see whether they can achieve 1/3 as quorum, but they couldn't do that. So when 3 people offer seats to do a business that requires 2/3 of the House, it is an aberration, it's an illegality, no matter how we look at it. So it is even logically wrong, very puerile and factical, for you to see a governor presenting a budget, a hallowed budget, of 800 million before 3 people in the House. It looks like a comedy when I watched it the last time. So these are the things that happen. So you must have to follow the law. The law is very clear. Right. Finally, on it is not about whether those people defected or not. 27 members is not the issue of defection, whether they defected or not. It's none of my business here. But the business of the court is that the 3 or 4 of you cannot sit and do a business that requires 2/3 majority to give the governor a go-ahead to begin to spend on that budget. That is where the question is.
All right, thank you, Mr. Sim. Your point is duly noted. However, given the peculiarity of the Rivers State political landscape, the 20-something House of Assembly members who defected were meant to understand that their case to decide the legality or illegality of the defection is still in court and has not been concluded. Now, would you say that the decision of the High Court in staying, the allocation of funds to Rivers State is a little bit hasty? Shouldn't they, some people think, shouldn't they have waited for the judgment concerning the legality of the camping of the 20-something House of Assembly members in Rivers State? What's your take on this?
They don't need to wait. That is where a lot of them are getting it wrong. There is no party, there's a court judgment, the Court of Appeal. The Federal High Court, first of all, for Motoshaw, affirmed and said that they have the imprimatur authority to sit. The Court of Appeal affirmed that decision of the Federal High Court that the 27 lawmakers have the premature authority to sit. But wherever they are sitting now is where the issue is. But they have the right. If premature authority means the right to sit. And if they have the right to sit, and no court has declared and said they cannot sit anywhere, or any court has declared them illegal or a higher court, then there is no law that is banning them from, sitting as they are sitting anywhere they want to sit right now. The position of the law right now is that those 27 members are still members of the House of Assembly until an appellate court says otherwise. So that is what is happening right now. So the court, Omotosho said, present the budget to the 27 members because they are the legitimate House of Assembly members. The Court of Appeal affirmed that particular decision. I said, go and represent the budget to them. It is only when the Supreme Court now decides, because that is the next stage the matter will go to. If the Supreme Court now decides, say no, 27 of you have defected. In that means that it now becomes the law, and nobody can begin to ask 27 members to sit. Let me, very hastily say here, and maybe conclusively say here, Section 287, sub 3, which affects the Federal High Court, says that any decision of a court of competent jurisdiction in Nigeria is bound to be executed by all authorities and persons in Nigeria. So all the decisions taken by the Federal High Court of Appeal and recently the Federal High Court in Abuja, by Justice Joy Malik, they become valid judgments until they are set aside. By virtue of Section 287, sub 3, it's a current judgment that has currency. It has life current, like what we have in NEPA current cable. If you touch it, anyhow, it will shock you, as the case may be. So these are things we must have to do. Nigeria is a democracy run under our constitution. We cannot go outside of it and begin to allow sentiments to sway us in whatever form we are doing. So that is just my take this morning.
All right, great. Mr. Asim, I have a two-edged kind of question, two-pronged question rather. First, I would like you to tell us what would Governor Fubara had done differently. Yes, you have pointed out certain breaches in the Constitution, but I want you to just in plain words tell us what Governor Fubara would have done differently. And then secondly, if I'll take your mind back to the early 2000s, there was a time there was this sort of tension between the Lagos state government and the federal government led by President Obasanjo at the time, where funds were withheld. Could you draw a little bit of contrast between what's happening now and what happened then? So is it two-pronged question? What would Governor Fubara have done differently, and draw a kind of contrast between what happened between the Lagos state government and the federal government, and what's happening between Rivers state government now and the federal government?
First of all, I have to answer the second question, because a lot of lawyers, even including senior lawyers who I respect so much in Nigeria today, have been, drawing allusions and conclusions, trying to simulate and choreograph that the River State imbroglio is the same with that of Lagos in terms of allocations we had. That is fallacious and factical, very factical, conclusion. It's a hasty generalization and conclusion by those lawyers. Let me give you the differences. We were taught at our elementary stage in our law school that no two cases are the same, that all the two cases are what we call pari material. The pari material are the same materials. No, it's not so. Let me start first of all. Are you aware that the judgment that was given by the Supreme Court in 2004, of which Tinubu, the president today, was governor of Lagos State, is quite different from what we have today? The first one is this. Are you aware that it was the president of Nigeria, Olusegun Obasanjo, that he sat down on his own and wrote a letter to Federal Minister of Finance. And as at that time, I think one Nadi Usman was the Minister of Finance. Obasanjo wrote a letter in his own handwriting to the Federal Ministry asking them to direct CBN not to give, not to release the allocation of Lagos state government to them until they comply with the Constitution of Nigeria. You know, Nanede Usman, the then Minister of Finance, based on that particular directive, you know, asked the central bank not to release allocations to Lagos state until they comply. You know what happened? The AG of Lagos state, I've forgotten the name of the young man then, the AG of Lagos state approached the Supreme Court and said that a sitting president, a member of the executive arm of government, cannot, you know, arbitrarily and brazenly, you know, request without a court order, request the Federal Minister of Finance not to release allocations meant for a state. And they went to court. I remember the late F.R. Williams was on the side of federal government. And you had some other titans who were on the side of Lagos State, etc., as the case may be. The Supreme Court came and said the president does not have that imprimatur authority to do what? To direct Federal Minister of Finance, to direct CBN not to release allocation to a state. That is the difference. But in this particular case, it was a court of competent jurisdiction. It was not Wike that wrote to the CBN. It was not even, you know, the president that wrote to Minister of Finance or CBN to stop giving allocation to Rivers State. It was a court order. And not just a court a judgment, it was a court, you know, judgment on the merits. On the merit mean that both parties for State Fubara and Rivers State all brought their pleadings before the court. And the court decided on the pleadings of the two parties and now arrived at this decision. So nobody can question that. So based on the currency of Section 287 that I mentioned before, that particular judgment, whether rightly or wrongly, becomes the law. And that is why we have the appellate jurisdiction of courts. Now, if the Federal High Court, assuming without conceding that the Federal High Court was wrong, is it by going on social media engineering to begin to incite people against the judiciary? No. What they ought to have done, which rightly they have done, is to rush to that particular court to do what they call stay of execution. A stay of execution can be, you know, derived at the Federal High Court that gave the order, or if it refuses, you run to the Court of Appeal to get a stay of execution. So any which way you have that right to get a stay to arrest this particular judgment that was given, but they have not done that. So these are two parallel, you know, issues, and I'm ready to debate with the highest echelon of those who are supporting Sim Fubara in this particular, you know, whatever we are doing today on this particular mantra. Then two, to your first question, because of time, what Sim Fubara would have done was this: the man has been acting like a chameleon to his supporters. Let me use the word his supporters, even though they are Philistine carpetbaggers, opportunists, who are, you know, edging him on for self-destruct politically. Now, what he would have done, you submitted yourself. You did not inform your supporters or those close to you. You submitted yourself to a presidential, you know, panel that was set up surreptitiously, secretly, without us even knowing. We discovered you went to Abuja to meet President Tinubu. Ordily went with you, and some other people went with you to go and resolve this particular matter. As at the time Sim Fubara was leaving for Abuja, he did not even go with Edison here, his then Speaker of the House of Assembly. He did not even go with him. He did not even go with Oko Jumbo that is talking about it. But he went to Abuja alone to go and cut a deal without informing his loyalists I've named or I mentioned before now. He got there, a 10-point or 8-point agenda was married. You signed it. You confirmed that you signed the agenda, and nobody put you under duress for you to sign it. When you got back to Port Harcourt, you know, the Philistine carpetbaggers, those who have access to grind with Yeso Wike, now said, no, you cannot, you have to undo what you have signed. You now begin to plead the legal principle of non ex partum, not my deed.
Mr.
Then you now get in that particular
Mr. Adams, can you
resolution
hear
between you
us?
and the president. Then you understand. So,
Mr.
Hello?
Adams.
Yes.
Sorry, I have to cut you short now because of time. But before I let you go, finally, I mean,
Yes.
this is a battle between the federal government and Fubara. But then again, the people are going to be impacted. In just 2 minutes, how do you think this will affect the state's ability to provide essential services? Just 2 minutes, please.
they know how they go about it. Some of the governors in Nigeria go to banks and borrow money from them, from the back door without following constitution. River State Iran, forget the sentiments they are talking about. If the governor wants to feed his family with 100,000 cows today, he needs money, he will get the money to do that. Forget about these sentiments they are doing. The state will keep running. They will go to their banks, and the banks will give them loans or whatever through the back door because they know that this matter will be settled, as case may be. But before I go, sir, those who are saying that the court does not have the right to say they should withhold allocation, the Supreme Court, quite in June of this year, the Supreme Court gave a judgment that any particular state that does not allow direct allocation of local government funds, to them, that the allocation will be seized. Was not a court that gave the order. Why were they not against it? Why are they against this particular order given by this court?
Mr. Adams.
This is the question we should ask.
Yes.
How will the state be able to provide essential service for the citizens?
They are providing it. They have banks that gives them. I don't want to call the name of the banks. Every state government. I gave you for an example now. If the governor saying people that needs 100 billion naira now, banks will give to him through the back door. All governors in Nigeria have been doing that with their banks. They have relationship with their bank. The state will move on, pending when they get the money. They are not saying it should be forever. Now the appellate court will, decide on this very soon, and the matter will be resolved. So the state will keep running. You cannot tell me that because there's no allocation does not mean that government has Port Harcourt will not operate. They will keep feeding. They will keep writing their cards. So why are they going to do that? They should pay workers their salary. And bury. Let them go and borrow money from banks. They have been doing it. So it's not something of sentiment.
Mr. Adams. Yes, this is the much we'll be able to take from you. Thank you very much for coming on the show this morning.
Joining us in the show.
Thank you. God bless you.
Now we'll have another interesting conversation. If you've enjoyed this, then trust me, what is coming next is going to be an amazing conversation. We want you to stick around. Don't forget to go to all of our social media platforms. We want to hear your comment. See you after this.